My name's Hamish and I head up our commercial property department at So Legal. I have two cracking solicitors within my team who are here today, James and Seema, and a paralegal as well. So I'm going to be talking about the property aspects to an asset business sale. As Ahmed said, there's two types of transaction. First of all, a share sale where the properties are owned or leased by the company and the shares of the company are being sold. And in this instance, the property role is corporate support. The corporate take the lead on that. For asset sales, it really depends on the nature of the business. If it's primarily property-based, then property tends to take the lead, whereas if it's more business-based with little property, then corporate will. For example, Ahmed and I recently acted on the sale of a prestigious restaurant in Brighton, which involved the grant of a sublease, and Ahmed assisted with the warranties. We had Adrian assisting with the employment, and then I did the property work. How do I move slides down?
It's also head of IT. Just press that arrow.
Oh, yeah, thanks. So when you're selling a business, the first thing a client asks me, a buyer or a seller, how long is it going to take? They don't care about the legal process. Why should they? They just want to know when they can sell their business or buy their business and move on with their lives. And the time scale could be shaved immensely if everyone was prepared. Accountants get not usually instructed at the outset because they want to know whether it's going to be a share sale or an asset sale, whether they need to set up a limited company. But solicitors should also be instructed before, at the time the property goes to market, so we can get everything ready. So as soon as a buyer is found, we can just send out the pack, and the landlord's been briefed, and we can get everything started straight away, because there's often a 2 or 3 week delay whilst all this information is collated. So the buyer's going to want replies to commercial property standard inquiries and also business inquiries. And within those inquiries, there's going to be a number of documents that are needed, such as employment contracts, an inventory of fixtures and fittings, the copies of the lease, any previous deed of assignment, license to assign, and any licenses to alter, because the buyer's going to need to see those. Title, if it's a leasehold property, the leasehold title. If it's freehold, if the lease is unregistered, it'll be the freehold title. Any contracts included within the business, any equipment on lease hire or HP, any statutory certificates such as electric and gas, utilities bills, rates and invoices, and also if it's a food-based business, they're going to want to see the food hygiene certificates. Regulatory documents such as EPC, asbestos survey, fire risk assessment, also the buyer's going to want to have a look at. And any planning documents, if you've had a change of use or got building regulation approval or planning consent for any works, that's all going to be included within the due diligence. It might be worth giving the landlord a heads up if you're going to sell the business and assign the lease, just to gauge their reaction and what their requirements are going to be. And also, as Ahmed said, be prepared for any tax elements, the apportionments, VAT, and also capital allowances are going to be a consideration. Get your accountant on board to give you any capital allowances information. So the process, when you're acting for the seller, typically it's either going to be the sale of an asset business with a leasehold property or a freehold property. Where it's a leasehold property, you're going to need to get the landlord's consent for the assignment of the lease in conjunction with the sale of the business. And that can cause a delay because the landlord is a third party and they're not getting anything out of the deal, as it were. The assignment provisions in the lease will provide that the landlord cannot unreasonably withhold consent. So as soon as we're instructed, we write to the landlord requesting consent. Now, there's also in the lease a number of conditions and circumstances to which the landlord can unreasonably withhold consent. For example, there's a condition, usually a condition in the lease, that the seller has to give an authorised guarantee agreement. That means that the seller will be guaranteeing the buyer's obligations under the lease. That's called an AGA. If the seller has given a personal guarantee, the landlord can also ask that personal guarantor to guarantee the obligations under the AGA, as it were. But what the landlord can't ask is for that personal guarantor to guarantee the buyer's obligation, if that makes sense. Those are called AGAs and GAGAs. There's also circumstances, so those are usually that the buyer is of sufficient financial standing, that all the sums paid under the lease are up to date, and that there's no material breach of covenant. Now, the breach of covenant usually comes into play where, for example, you've got a fully repairing lease, which, as I'm sure a lot of you know, means you must keep the property in A1 condition. and give it back to the landlord in that condition, even if you didn't cause the disrepair. So it's basically mint condition. So if the property is in disrepair, the landlord may refuse consent on the basis that those repairs remain outstanding. Now, what usually happens in that scenario is either the seller carries out the repairs themselves, which tends to delay matters, so that's not usually the best option, or secondly, a sum is paid by the seller in lieu of the dilapidations and it's deducted from the purchase price. In that case, the landlord will also probably want to see a provision in the licence to assign requiring the buyer to carry out those repairs within a certain period so that the buyer just doesn't keep the sum in lieu and that they're actually used to repair the property. So I've seen several deals, it's very rare thankfully, if you've got a difficult or uncooperative landlord, fall out of bed or be delayed because the landlord's asking for unreasonable conditions. For example, the landlord can also ask the buyer to become a personal guarantor. A lot of buyers don't like that. They want to keep the liability of the lease within the limited company or a rent deposit. So it's really dependent on the buyer's situation, whether they've got the cash to pay the rent deposit or if they haven't, whether they're prepared to give a personal guarantor. Landlords can be very difficult sometimes and ask for lots of different security and that can delay or sometimes, unfortunately, kill a deal. There is the opportunity to apply to the court for a declaration that the landlord has unreasonably withheld or delayed consent, but that's so costly and time consuming it's not normally viable. So with freehold properties, the process is a lot simpler because it's the seller who is the property owner, so they're selling the business and selling the freehold at the same time, or alternatively, if they want to keep a rental income, they're granting a lease of the property to the buyer and also selling the business. So the process when acting for the buyer, as I've said before, they want to see the CPSEs and business inquiries, replies to those. They want to check the regulatory issues. As a commercial tenant, you have a number of statutes you need to comply with, such as asbestos regulations. If the property is within a certain age, you need to get a survey just to check that there are no harmful products that need to be either removed or monitored, and you have a duty to your employees and any contractors carrying out repairs to get a survey. Fire safety regulations, you need to have a fire risk assessment in place and maintain a fire management plan. Energy performance certificate, so you need to provide an EPC if you're assigning the lease, and also check whether the gradings caught by the regulations. Under the lease, as a tenant, you have to comply with any statutes, so you don't want to have to spend money on improving the energy efficiency of the building. Obviously, electric and gas safety certificates are important for the complying with any statutes. And air conditioning, it's important to ask whether it contains the ozone depleting refrigerant gas R22, as that's been illegal since 2015. And if it contains that gas and you have to upgrade the system as part of the lease covenants, then that's going to be really expensive. We'll want to carry out the usual searches for the buyer, so that would be typically the local authority, which will show the planning history, the nearest adopted highway, whether there's any outstanding notices which, under the terms of the lease, the tenant may have to comply with. Environmental searches, particularly if it's on an industrial estate, it'll disclose whether the property could be considered contaminated land. It's not a site investigation, it's just a desktop search, so not 100% reliable, but it will give a good indication as to whether you need to look at that further. And also, it will disclose whether the property is in a floodplain, which may have issues when you're trying to get insurance. And also a drainage search, so that'll reveal whether the property drains to the sewerage system and is connected to the mains water. And it will also produce some plans so we can see whether any easements are required if it crosses third-party lands before connecting into the mains. So when acting for the buyer, we provide a number of reports. We give a title reports, a replies to inquiries report, which deals with the regulatory aspects, a searches report, and also a lease, and if there's a rent deposit report once the documents have been finalised. Very important, we always advise a buyer or tenant who's taking on a business or having a lease assigned to them to get a survey. As I said, a fully repairing lease requires them to put the property in A1 condition, and a survey will reveal any hidden defects which, if dealt with before completion, you can try and ask the seller to chip in for that. And finally, tax issues. So the property taxes, so you've got stamp duty, land tax. I find lay people don't tend to realise that stamp duty land tax is payable on leases. So if it's of a high rent and term, you have to pay stamp duty land tax on that, depending on the amount of rent and the term. And what's worse is that if the landlord has opted to tax the property so that he charges VAT on the rent, you have to pay stamp duty land tax on the VAT inclusive figure. So the government have said you've got to pay tax on the tax, which is pretty galling for buyers or tenants. So yeah, that's one of the questions we ask the landlord in particular if we're buying a business. Firstly, I ask them to provide the insurance details, and secondly, have they opted to tax the property? Freehold stamp duty, obviously you have to pay stamp duty on a freehold property if it's over the threshold, and depending on the amount of the purchase price will depend on the amount of stamp duty land tax. And also, although it's not on the slide, capital allowances. It's quite important to make sure you've spoken to your accountant as to whether you've claimed the capital allowances up to the date of completion, because if so, an apportionment needs to be included within the contract and an election made. And that's important for the buyer as well, because if the contract is silent and the buyer tries to claim capital allowances in the future, HMRC will want to see evidence within the contract and replies to CPSC whether capital allowances have been claimed in the past. So completion, that tends to just involve standard documents, transfers if the lease is registered, or a deed of assignment if it's not, deed of assignment of goodwill, receipt for fixtures and fittings. If the property sells alcohol, then it will be the transfer of the premises licence as well. And timescale, I usually say 2 months for a business sale, but if you're prepared, it could be 1 month. Thank you.
Calm down, one more slide.
It's one more slide. Actually, the other thing, VAT that you mentioned, I forgot about this, but if your buyer is not VAT registered or not intending to be VAT registered, but the rent is subject to VAT, they can never claim it back. So again, you need to speak to an accountant about these things. Actually, listening to what Hamish has said and what we put together, I think we're too cheap on stuff like this. There's so much involved. There's so many, there's minefields everywhere for us. So at completion, as Hamish said, we put everything together, we get all the documents, and then we get them all signed, money comes in, and we complete. So that's the process. Just to give you one final horror story from an example of something that I come across. I was selling a business for a client, leasehold property, as Hamish alluded to, like on the leases. And what they had done was hadn't actually used a solicitor when they took the lease. So it was a cafe or restaurant, if I remember correctly. But they hadn't registered the lease, which they had to. It was a 15-year lease. The landlord had just given them a law society lease to sign, which they had. They hadn't paid a stamp duty. So the issue was actually we've fallen below 7 years left on the lease. So we couldn't register the lease. The lease had to have been registered. There was a stamp duty, land tax payment, penalty and interest. And the buyer was, asking us to regulate the situation. We had to apply to the landlord to get a new lease for the buyer. And they said, well, you're going to have to pay for the stamp duty on a new lease. So it just goes to show, if you don't use a solicitor or you use a bad solicitor, you end up with a minefield of problems at a later date. We're not just talking about using us for your purchase or your sale now, but actually it's using someone bad at the outset and then using someone at a later date to sell your business. That's obviously where you could fall foul of certain things like that. So yeah, that's in a nutshell how to buy and sell a business on an asset basis as a going concern. There's a lot more involved. I could have gone on for hours, rock and roll, but that is in a nutshell what it is. Any questions? Anyone got anything that they want to ask? Richard Garland, Gradient Consultants.
Thank you, Hamish.
No worries.
Great presentation, guys. Really interesting, really useful. Didn't really talk. We hear a lot about mergers.
Yeah.
Would you recommend that you go through exactly the same process if you were talking to another company about merging?
Well, okay. If you were merging businesses, what you want to do, who's the dominant and who's the... No, because what you want to do is you don't want to end up buying all the liabilities of the target. So if you're the dominant business and you want to amalgamate the smaller business into yours, you need to really think about, what am I buying here? what's the reason for the sellers? Are they retiring? Are they looking for succession planning? Are they looking to add their service to your services? And what you really need to consider there is, am I buying the shares in their company and amalgamating them as a subsidiary of my holding company, or am I just going to do what's known as hiving, which is you hive off the assets, the goodwill, fixture and fittings, transfer to staff, and then they deal with the company aspects. There's tax issues there for the seller. So if you are the dominant and you're buying somebody out, let's say they're succession planning and they're retiring, they will want you to buy the shares in their company for entrepreneurs relief because they pay 10% flat rate on the sale proceeds. If you, however, then say, well, look, I don't want that. What I want is I just want the assets. The liabilities can stay with the company. I just want the contracts that you have. You need to consider, are those contracts signable? Is there a provision in those contracts that they need to get the other contracting parties permission to transfer to you? That's one aspect. The staff will need to be transferred under 2P, as I've explained. You will need to obviously pay them for that, but from their point of view, for tax purposes, once they get the purchase price, they've got to pay corporation tax on that, and then whatever's left to give to the shareholders, dividends tax on that. So there are issues, although I think that some form of entrepreneurs tax can exist, but I'm not an expert on that. That's why you need to speak to an accountant. So it just depends on what, personally, I let's say there was another law firm that we were buying, we would look at just buying the specific department and the assets and transfer the staff. I wouldn't want to buy liabilities. So if you buy the shares, you buy warts and all. So you buy everything, all the good stuff, all the bad stuff, and the hidden stuff. And no matter, you could have the best lawyer in the world, you know, Erin Brockovich could be acting for you on the share purchase. But you won't. There's things that you'll never know. So I can speak to you about it later if you want to speak about any specifics. Neil?
Again, thank you.
No worries.
Very much about, obviously, you said at the beginning it's going to be about asset purchase, not share purchase,
Yeah.
and you just touched on some of the benefits there.
Yeah.
Is that something you really would recommend a client if you're going out buying businesses, that it is asset and not share?
It all depends on the circumstances. It all depends on the circumstances. There are benefits to share purchases. For example, you don't need to novate or assign any contracts that the business is subject to because you're just stepping into the shoes of the shareholders. The contracting party, the company, remains the same. If you've got leasehold properties, you don't need to get an assignment of the lease from the landlord unless the lease has a change of ownership provision, which is very rare. So that provision is basically, it says that the tenant is a company. However, if the ownership of the company ever changes, the landlord can consent as if it was an assignment to those changes. It's very rare for that to be in there. It's got to be someone very sharp that puts that in there, and you don't see it all the time. But obviously, buying the shares in the company, you buy all the assets. The leases, the contract. You don't need to transfer it across. The staff are already there. You don't need to 2P them. As Hamish said, capital allowances you need to think about because it's part of the company's asset. But then you've got all the liabilities. It really all depends on what you're buying. It really does. And also the seller's perspective and what they want to gain from it. You know, tax, are they retiring? Are they leaving? What's happening? So it really is on a case-by-case basis. I'm seeing more people move towards share purchases and share sales for really small businesses as well. We got instructed yesterday on a hairdressers for 30 grand, and they're doing it as a share sale because they don't want to get the landlord involved for an assignment of the lease. And they just want to transfer. They said, look, we're just going to get a stock transfer form. We don't even need a contract. There's a stock transfer form. Can you just deal with removing me as a guarantor from the lease? And I said, yeah, but there is a little bit more involved. You're going to need at least some form of contract to transfer the shares. So, yeah, you know, we get that a lot. Or can you check the document that I've drafted and tell me if it's okay? That's another classic. So it just depends. It depends wholly on what you're doing. If you are looking to expand your business and you're bringing these other businesses under your corporate structure, it might be better for you to actually just buy them as asset-based businesses, transfer the staff in, and then you can obviously not take on any of the liabilities, but take on the businesses. So yeah, it really does. Again, I can have a chat with you later about that.
Thank you.
Anything else? Any other questions? No? Okay, great, brilliant. Well, we're here all day anyway, and as Hamish said, we've got Seema and James here, two very, very good lawyers that we're lucky to have at our firm, and they were here to speak to you about anything as well. So yeah, that's the business sales and purchases presentation. We'll have a quick break and then we'll bring Ewan and Andy in for their viability planning and design seminar, and we'll go from there. Thank you. Cheers.